All right, Mr. Martone, are you able to hear me okay?
I can, Your Honor. Good afternoon.
All right, good afternoon. I don't see Mr. Traskos. Have you been in contact with him at all about the status conference today?
Well, sort of yes and no, Your Honor. I don't actually anticipate him attending, in part because he notified me late yesterday that he was actually having a surgical procedure performed this morning and was going to be out of the office today through the balance of the weekend into early next week. Also, in full disclosure, because the parties had submitted a stipulated order extending the dates back in December, I don't know if Mr. Traskis believed that today's hearing was going forward. Or not. And so I had emailed him today asking if he was intending on having someone appear, and I have not heard back. So in fairness to him, if the court was inclined, I'm happy to pick another date that may be also convenient in light of his medical procedure.
Okay. All right. So yeah, I am looking at that stipulation to extend. That makes sense. So let's see. What's the current 75 days? So if I set this for another status conference in March, do you have any objection to that?
No, I would not, Your Honor.
Okay. Okay, anything else that you wanted to state for the record today?
Not at the present time, Judge.
Okay, thank you. That's all for today, and thank you for appearing to kind of enlighten me on what's going on. I appreciate that.
Not a problem. And Happy New Year, Your Honor.
Okay, thanks. You're free to
Yep.
disconnect.
Thank you. Bye-bye.
Oh, Mr. Isles. All right, looks like we have everybody connected, so we'll go on the record in Crystal Gentz representing this estate of Cynthia Smith versus William Smith. This is file number 251183329. And if I could have everybody put your appearances on, please.
Dave Lobello on behalf of the defendants, Your Honor. Good morning, or good afternoon, Your Honor. Timothy Dine appearing on behalf of Mr. Giroux in this matter.
And Scott Isles on behalf of Crystal Gentz as the executive of the estate of Cynthia Smith.
All right, Mr. Giroux, did you want to put your appearance on as well? Your listed counsel in this case?
I don't know if you can hear us.
Mr. Giroux, are you able to hear me okay?
Want me to call him, Your Honor?
Yeah, I think so. I'm not sure he was connected there.
We can see you. We can't hear you. We're trying to talk to you to have you put your appearance on the record. Okay.
But he needs to connect his microphone.
Connect your microphone. Right,
Is he able to, what did he say?
he's gonna connect with us.
Okay. There we go. Okay, Mr. Drew, are you able to hear me?
Yes, I am.
Okay, great. Can you just put your appearance on for me, please?
Certainly. May it please the court, Robert Giroux appearing on behalf of the plaintiff, Crystal Gens, as personal representative of the estate of Cynthia Smith.
Okay, thank you. We're on the record today for a couple of different matters. We have 3 motions up from the defendant, and then we also have this set for a status conference today. I did have a chance to review the motions and response. And so I guess I'd like to just start with what I view as the most substantive motion here, which is the motion to disqualify Mr. Giroux. So Mr. Lobello, did you want to present any oral argument in support of that? I guess when I first saw the motion, I mean, I've been on the bench for 13 years. I've never had a motion by an attorney to disqualify another attorney. I always thought that those were matters within the scope of the Attorney Discipline Board and Grievance Commission. If an attorney had violated the rules of professional conduct in some way, that was something outside the scope of what the court would do. So I was a little surprised to even see this as a motion. But I obviously I read the authority that you cited. Was there anything you wanted to state in terms of oral argument in support of that?
Well, Your Honor, I'll be brief because the court has read the submissions. I think maybe striking at the heart of the matter here is that there is a waiver from Ms. Gens, as well as my client, Mr. Smith. I wasn't consulted or made aware that Mr. Smith was communicating with Mr. Giroux. But even if the court finds that the waiver is valid, the circumstances in this case are such that I cannot convey or talk to my client and convey my thoughts and mental impressions to him without fear of it being suffused, so to speak, to the other side, which impairs my ability to do my job. Ms. Gens and the estate are adequately represented by Mr. Isles in this matter. It's obviously their prerogative to hire as many attorneys as they'd like. Same for Mr. Smith, but as far as the administration of justice in this case goes, Your Honor, I believe that disqualification is necessary. And as the court cited, this is a matter that is properly before the court. This is not anything that's brought before that I've brought before the Attorney Grievance Commission in that regard, simply limited to the nature and scope of what the issues are here in this case.
All right, and so who's going to argue this on behalf of the plaintiff?
Your Honor, I'm going to be arguing on behalf of Mr. Giroux, if that's if the court approves of that.
Okay, yep, and I have no problem with that. I just want to state for the record, typically when I have multiple counsel in any given case on any issue, I do only allow one attorney to argue a motion. So, Mr. Dinan, if you're taking the reins of this one, just so everybody's aware, I would only hear argument from Mr. Dinan on it, not the other two councils. So as long as you guys are all okay with that, Mr. Dinan, you can proceed.
Thank you, Judge, and thank you for taking the time to review the pleadings. Really, this is a few issues exist here. The court perceives correctly that it's a client's prerogative to hire their counsel of choice. Mr. Giroux built up a good relationship with William Smith when he first provided services to him right after the accident in 2022. My client is an expert on practicing personal injury law. He is a seasoned trial lawyer and someone that Ms. Gens found to be a great choice to be on the team to pursue the claims that she has in this matter. Your Honor, the court is going to need to look at this matter from from the standpoint of the freedom to contract who a client wants to hire. And then, yes, there is an appearance of a conflict of interest. So the conflict would arise on its face because Mr. Giroux represented Mr. Smith at the time of the accident in a limited capacity. He was present for a statement under oath, and he helped him prepare forms. There was no criminal action that arose out of the accident, and there was no other lawsuit that was ultimately filed on behalf of the estate where Mr. Giroux had any further action. Ms. Gens approached Mr. Giroux to represent the estate for the purposes of trying the case if that was necessary. So the thought is that first, is there a conflict on its face? Yeah, it would appear to be a conflict on its face. The second question is it directly adverse to the interests of Mr. Smith to have Mr. Giroux represent the estate? And the answer to that question is no. First of all, Mr. Smith is in the unique position of being the former husband of the late Cynthia Smith, and also the stepfather of Crystal Gens. And in that regard, he has interests that he'd like to see prevail. The fact that the counsel can't speak with his client openly and frankly, that problem would exist anyway because there's this affinity between Ms. Gens and Mr. Smith. So I believe this is a matter where it was necessary to get the proper waivers, which were executed and are part of the exhibits to my response to the motion. And there's really no demonstration of how or what information that Mr. Giroux would have that's not already part of the public record, and that the insurance company and Mr. Smith's counsel don't already have. So I don't think it would be appropriate to tell the estate who they can't have as their attorney in this matter. And I think it's advantageous, too, that Mr. Giroux would bring in previous knowledge of the case that would be helpful in the prosecution of it. Finally, Judge, it's Mr. Smith's prerogative to waive that interest, and he did so appropriately in a form that would be approved under the court rules.
Okay, thank you. Mr. Lobello, it's your motion. I'll give you an opportunity to respond to any of Mr. Dinan's arguments.
Well, Your Honor, I think Mr. Dinan hit it on the head as far as Mr. Giroux's ability to bring in previous knowledge about this case and its prosecution, which I think just goes more towards the fact that this is a wholly adverse relationship here, on top of the fact that I'm not aware that Mr. Smith has terminated Mr. Giroux in terms of his representation. So the air of Mr. Giroux representing the estate and Mr. Smith potentially exists because I haven't seen anything and I didn't see anything in the responses that the termination or the representation has ended between Mr. Smith and Mr. Giroux. So with that, Your Honor, I again just go towards the scenario of how this plays out in trial if we get to that point, is that Mr. Giroux potentially has information from Mr. Smith that isn't divulged to me, or is somewhat of a surprise due to the prior confidential relationship or the existing confidential relationship. I certainly have no ability to control what my client says to his stepdaughter about the case, and certainly it's not under any sort of ethical rule in terms of their communication. But I think the problem in this case here is patent, Your Honor, and we move for Mr. Drew to be disqualified.
All right, thank you. So I did have a chance to, again, look at the law that was cited by both the parties in this case. And to go over the briefs, the arguments of counsel here are pretty consistent with the arguments that were made in writing. I do think there's two issues here. Number one, there's the waiver by Mr. Smith. I had a chance to look at that. It was attached as an exhibit. It does appear to be a proper waiver of conflict that was signed by Mr. Smith. It indicates, and the court has no reason to believe otherwise, that Mr. Smith indicated he had an opportunity to consult with counsel, whether that was Mr. Lobello or not, had an opportunity to consult with counsel before signing that waiver. And the fact that Mr. Lobello may have come in later, or that Mr. Smith, if Mr. Lobello was involved at the time the waiver was signed, that Mr. Smith made the decision on his own not to consult Mr. Lobello, I think isn't the burden that's borne by the plaintiffs in this case or by Mr. Giroux. I think that's a decision that was made by Mr. Smith of his own free will, and I think it would. There's no suggestion that was somehow improperly influenced or done without some kind of full disclosure to Mr. Smith, who is the one with the right to either waive or not waive that conflict, not his attorney or anybody else. So I think the waiver is a significant hurdle in this case. I don't find any reason to invalidate the waiver. And so for that reason, I don't think the court even needs to go into the other arguments or further analysis. We've got a proper waiver, and I don't think for that reason Mr. Giroux should be disqualified. However, even if we do look into the merits behind it, it's clear to me, and I don't think it's been contested, that there was very limited representation by Mr. Giroux earlier on with regard to Mr. Smith, that there wasn't any information disclosed to Mr. Giroux that wouldn't otherwise be available through documentation. And certainly Mr. Smith can discuss anything that he has discussed with Mr. Giroux, with Mr. Lobello, and make Mr. Lobello aware of all of those things as well. So the court doesn't find that there's enough of a conflict there to warrant what I view would be a fairly extreme step of, as indicated by the plaintiff here, of forcing the plaintiff to get a different counsel. So for those reasons, the court finds that there aren't grounds in the context of this litigation to disqualify Mr. Giroux. Now, I do want to state for the record that, obviously this court does not sit as the Attorney Grievance Commission or the Discipline Board. This court is not an expert in the rules of professional conduct and the ethics opinions that have been issued over the years. And while some were cited to the court as part of this motion, certainly not part generally of this court's practice or research. So I'm going to state for the record that I take no position, and this ruling should not be interpreted later on as any kind of finding that there absolutely would not be a violation of the rules of professional conduct by Mr. Giroux's continued representation of the plaintiff in this case. I would leave that, again, to the Discipline Board or the Grievance Commission later on, to the extent that anybody files an action in that, to make that determination. I'm simply making a legal determination as a matter of law in this case. I don't find that Mr. Giroux should be disqualified. And the wisdom, I'm not going to speak for Mr. Giroux. He's a very experienced and very professional attorney. But I think everybody's proceeding at their own risk here. And it seems like, given the number of qualified counsel here may be a risk that nobody really needs to take, but again, that's not for me to determine. So all of that having been said, I return back to my original ruling, which is the court will deny the motion for disqualification. And so I would request, Mr. Lobello, that you prepare an order reflecting that ruling to the court for the reasons stated and submit that under the 7-day rule. And then Mr. Lobello, your next motion was a motion to amend the scheduling order. And Mr. Dinan, I'm assuming, are you going to kind of back out now that your part is done?
Yes, Your Honor, I was hoping you were going to ask. I wish you all very well, and thank you for your time this afternoon.
All right, thank you. So Mr. Drew or Mr. Isles, either of you oppose that motion to amend the scheduling order?
Yes, Your Honor. I filed a response to the motion just indicating that the letters of representation or the letters for Crystal Gens being named the PR and continuing the PR for the estate, those were provided to defense counsel a while ago, and they've been available for quite some time. It's a matter of public record. In addition, the records from both the decedent's gynecologist office and her PCP, the authorizations have been provided. I don't know that that really adds anything or takes anything away from the case, but certainly defense counsel has that now to the degree that it wishes to use that to defend the case. I don't see anything else in the motion that they indicated they needed, and I request respectfully that we just move forward with what's next on the normal course of things, which would be final pretrial and then a trial.
Okay, Mr. Lobello?
Well, Your Honor, and I believe we disclosed this to the court, that some of the information that we sought to compel was provided. There was a partial withdrawal filed, namely as to the motion to compel. But there is outstanding information that we're looking for from the plaintiff's aspect in terms of what happened with Toyota. Toyota is a non-party to this case. I did receive some information from Toyota's counsel that was limited by the agreement between I and Toyota's counsel. However, what I'm seeking to obtain is whatever information the plaintiffs may have with regard to that issue with Toyota, given their position with regard to their experts saying that there is no malfunction with the airbag or the vehicle in general at the time of this accident. So in part with the motion to compel and without mingling the matters, Your Honor, that's the reason we're looking for further discovery. Also, as the court indicated previously, we have the deposition of Mr. McDonald coming up. I've sent Mr. Isles some proposed dates that I'm trying to confirm with Mr. McDonald to accomplish that within this month. And, we're essentially just seeking more time, Your Honor. And then after that, I like to resume talks in terms of mediation. I reached out to Mr. Barney on Monday to inform him of what was going on as he asked for a status update, but that's the tentative plan thus far, Your Honor. And I suppose, without mingling the matters, maybe that answers some of the other questions that we have before the court today.
Yeah, thank you. So Mr. Drew, what's your position on the discovery request?
There are no outstanding discovery requests to the plaintiff as far as I know. There was a request that was ultimately turned over to an attorney named Bob Tyler and another attorney whose name escapes me. He represented Toyota. To my knowledge, that was all resolved to Mr. Lobello's satisfaction. I think the attorney for Toyota and Mr. Lobello reached an agreement. I saw evidence of that agreement in emails. I also saw evidence of compliance with that. That particular matter was not something that was ever filed. There was no litigation. It settled pre-suit. There were no expert affidavits and no expert testimony in that case. Mr. Lobello sought the amount of the settlement, which was given to him. He sought Toyota's understanding as to what the allegations were. He was provided with that. And he wanted to just see who the settlement was between. And he was given that information. So that is all that was requested, and I believe that's all been satisfied. I don't know I don't believe there's anything else outstanding relative to that particular issue. And I don't know if Mr. McDonald, defense's expert, who's been ordered to provide deposition testimony because we couldn't get it otherwise, I don't know if he's going to address those issues or not, but I don't think we need to extend discovery just to have the deposition, which was court ordered, because it was properly requested during the course of discovery. So I think the dates are next Friday, the following Tuesday, and Wednesday. If those are the dates, we'll get that deposition done here in less than 2 weeks.
Okay, Mr. Lobello?
Your Honor, there was some mention, and this was during the recorded statement, I believe that Mr. Drew was present for, or some discussions during his former representation with Mr. Smith, that Tim Robbins had done some work on this case, or was going to be retained to do some work on this case. So that's the discovery regarding Toyota that I'm looking for. And I understand that Mr. Drew is saying there was no affidavits or reports generated by any experts, but I just like the ability to investigate that matter, if the court will permit.
Is that the subject of an existing interrogatory or discovery request?
Your Honor, we had sent discovery requests. I believe it was in the week or weeks prior, maybe 2 weeks prior to the close of discovery in this case. Mr. Drew responded saying we don't have enough time to answer this, in an objection, and no response was provided in that regard. And that's when Toyota's counsel and I started communicating, and I did obtain some of the information that I was looking for. But again, I'm just trying to dot all the I's and cross all the T's here.
Your Honor, to be fair, and I don't mean to be throwing stones, I really don't. There was nothing in the discovery request that specifically sought anything about experts, anything about expert consultations, anything about Tim Robbins or his company. None of that was the subject of a discovery request. It's true that defense counsel sent, I think, literally days before the discovery cutoff, a request for information regarding the resolution or any sort of settlement with Toyota. We did object, as was proper under the court rules, saying, look, the court rules say you have to send it well enough of the discovery cutoff that there's time to answer. However, because I don't believe in just conducting business like that, I filed the appropriate response with an objection. However, I did also point Mr. Lobello in the direction of where he could get the answers. I said, unfortunately, Ms. Gentz is covered by a confidentiality provision. Here are the attorney's numbers and here are their emails. Reach out to them and see if they will give you the information. I gave that to Mr. Lobello, and he followed up on that, and he got the information he sought. But there was not anything about Mr. Robbins. There was not anything about experts. And to suggest otherwise isn't really being completely candid, I guess I'm trying to say.
All right. Okay. Was there something else you wanted to add, Mr. Lobello?
Yeah, Your Honor, my discovery request was very broad in terms of what I was looking for. So to limit it in that respect, I think is not accurately depicting what I had asked for in my discovery responses. But in any event, I understand. So.
All right. What I'm going to do is, I don't think at this stage of the case, I mean, I don't think there's any harm in extending discovery as requested. Under Michigan court rules, discoveries should be broad and open process. And I don't think the case is so far along now that it would be unduly prejudicial or unfair to allow Mr. Lobello to look into what sounds like some pretty limited issues. So given the kind of the dispute over, the existing discovery request, number one, I'm going to grant the motion to amend the scheduling order and extend discovery as requested in the motion. The court is not going to grant any orders to compel discovery at this time, but what I would simply say is, Mr. Lobello, to the extent that you need to follow up with a more specific request, you'll have the time to do that. To the extent that you don't get sufficient answers or believe that you don't, then that could always be the subject of another motion to compel if necessary. So, Mr. Lovello, if you can add that to the order that you're going to prepare as well. And then, in terms of the status conference, I simply will set this for another status conference at the expiration of the extended period of discovery, and then we'll go forward from there. Mr. Lovello, anything else that we need to address today from your
Nothing
side?
further on my end, Your Honor.
Mr. Giroux,
No, Your Honor. Thank you for your time and your consideration today.
Mr. Oz?
No, Your Honor, thank you.
Okay. All right. Thank you. That's all for today, and everybody's free to disconnect.
Thank you, Your Honor.
Mr. Giroux pledged my fraternity
Oh.
back when. And then what happened was I was a Crawford manufacturer's rep. I ran into him, how's it going, this and that. I said, the problem is I'm gone all the time, travel. And I don't want to start having kids if I'm not going to be home. He said, well, I'm going to go take the LSAT tomorrow.
All right, we'll go on the record in Holtcamp versus Holtcamp. This is file number 2511974. If I could have both counsel put your appearances on, please.
Juanita Massey appearing on behalf of Stephanie Holcamp.
Thank you, Your Honor. Jason Thompson appearing on behalf of Matthew Holcamp.
Thank you. We're on the record today for a status conference and scheduling conference. Ms. Massey, first, from your standpoint, can you tell me kind of where things are at with this file and what you'd like to see for scheduling going forward?
Your Honor, unfortunately, our office just got retained a couple days ago, just filed our appearance. So we'll need some time for discovery. There's nothing resolved yet. Mediation would be helpful too.
Okay, Mr. Thompson?
I would agree mediation would be helpful. We haven't been able to make a whole lot of progress. Ms. Massey's office represents the third counsel for Ms. Holcamp, and so things haven't progressed yet.
All right, how much discovery do we need? Is 60 days enough? Ms. Massey, is that enough or do you want more than that?
I would want a little bit more than 60.
Mr. Thompson?
We don't need any more than that, but if the court chose 90, I would understand.
Ms. Massey, is 90 acceptable?
Yes, Your Honor.
Okay, so we'll have discovery remain open for 90 days.
Can we have mediation conducted within that same period, Your Honor?
Yeah, definitely. I was going to order that. My question would be, is this a case that community mediation would be acceptable, or do the two of you want to engage an attorney mediator?
I would recommend community mediation, Your Honor.
I agree.
Okay. So we'll refer it to community mediation and that to occur within that 90 days. And then what I will do is set this for a status conference at about 90 days. If the parties have been able to resolve this through mediation or otherwise, then we can use that date to take proofs and enter a judgment. If not, then we can see where things are at and either schedule further ADR or just set it for an evidentiary hearing for the court to resolve any remaining issues. Ms. Massey, any other dates that I can address for your side?
No, that's satisfactory. Thank you.
Mr. Thompson?
Nothing further for today's record.
Okay, so I'll put all of that into an order that'll go out to the parties. The court will also send out notice of the date and time of that next hearing in about 90 days. And all parties on this case are free to disconnect at this time.
Thank you.
Okay, it looks like we have both counsel connected, so we'll go on the record in JP Morgan versus Reed. This is file number 2511872. If I could just have both counsel put your appearances on.
Yes, Your Honor. Chris Royce, P49102 on behalf of plaintiff.
Good afternoon, Juanita Massey, appearing on behalf of the defendant.
And Ms. Massey, I don't see Ms. Reed present. Is she there with you, or were you not anticipating her joining in today?
I was not anticipating her joining today.
Okay, thank you. So this was set as a final status conference today. We do have a bench trial evidentiary hearing set for next Wednesday, the 14th. Mr. Royce, has anything changed? Are we ready to go forward next week?
Your Honor, first of all, I don't think 99% it's going to be settled. With respect to me knowing what's going on, I don't. Our computer system is down, and I've been unable to check to the status of the hardship claim. So, regardless, I don't think it's going to go to trial, Your Honor.
Okay, Ms. Massey, anything you wanted to add to that?
That is correct. I sent paperwork over to Mr. Royce, seeing if Chase would do a hardship discharge for my client on the debt. I know he is still waiting on that, and with him not having the ability to check that today, we're unsure, but I think we can come to some type of settlement if there is no discharge.
Okay, so my typical practice is, unless I have, a representation that there's a settlement or actual closing documents, that I don't take those dates down just in case, because I do want to get this resolved one way or the other next week. So I'm going to leave that date up for next Wednesday. Obviously, I'm hearing both of you loud and clear here that it may not go, but if there isn't a resolution, then I need both of you to plan on, being ready to go next Wednesday. If there is a resolution prior to that, then please notify my office. I'll be more than happy to take that date down. And the sooner the better, because I can use that time for something else.
Absolutely.
But otherwise, that's how we'll proceed. Mr. Royce, anything further from your side today?
No, thank you, Your Honor. I appreciate your patience. It's been a frustrating morning.
Ms. Massey, anything further from your side?
No, Your Honor, thank you.
Okay, thank you. If you're both free to disconnect at this time.
Thank you. Have a great day, guys.
Thanks. Okay, we'll go on the record now in Fleming versus Walgreens. This is file number 2511842. And if I could have both counsel put your appearances on, please.
Good afternoon, Your Honor. Nicholas Marchena on behalf of the plaintiff. I'm here with the conservator and mother of the plaintiff, Wendy Stewart.
Good afternoon, Your Honor. Adam Fadley on behalf of the defendants.
Thank you. We're on the record here today for entry of a settlement in this case. Because of the circumstances pursuant to court rule, the court is required to hold a hearing and approve the settlement pursuant to MCR 2.420. I did have a chance to review the motion. I did receive the confidential settlement agreement. I had a chance to review that prior to the hearing today. And so, Mr. Marchena, typically what I do is leave it open to counsel to inquire of the conservator. So are you prepared to do that today?
Yes, Your Honor, I appreciate it.
Okay, Ms. Stewart, if you would please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand, and Mr. Marchena, whenever you're ready.
Thank you, Your Honor. Ms. Stewart, you are the mother of Rebecca Fleming,
Yes.
and you were appointed conservator on her behalf, correct?
Yes.
And that is because in part she, when this was filed, is a minor and also has a developmental disability, correct?
Yes.
On her behalf, you asked our law firm to pursue the lawsuit in this matter against the defendants,
Yes.
and you have agreed to the proposed settlement before the court today.
Yes.
You understand that this is a full and final settlement and that you can never bring another action in the future against the defendants for the claims at issue.
Yes.
You understand that you could have gone to a jury trial, received more, less, the same, or nothing at all.
Yes.
You understand that the amount and terms of the settlement are confidential.
Yes.
You have been provided a copy of the written motion before the court today. Is that right?
Yes.
You understand that there will be, if the court approves this, costs reimbursed to the law firm as well as an attorney fee deducted,
Yes, I do.
and that there will be probate fees paid to Attorney Howard Linden as well.
Yes.
Further, you understand that the medical insurances are not claiming liens in this case, Medicaid and Blue Cross Blue Shield. They are zero.
Yes.
You are asking the court to approve this settlement and distribution in the best interests of your daughter. Is that right?
Yes.
And you understand that should the court approve this settlement, that the funds after costs and fees will have to be distributed through the conservatorship in probate court.
Yes.
I have nothing further, Your Honor. Thank you.
Thank you. Mr. Fadley, did you have any questions for Ms. Stewart?
Yes, just very briefly, Your Honor. Thank you. Ma'am, my name is Adam Fadley. I'm the attorney representing the defendants. I do just want to confirm your attorney actually already provided it to me, but you signed the release and hold harmless settlement agreement. Do you recall that?
Yes, I do.
Okay. And just to confirm, you understand that that releases and relinquishes all rights to make any kind of claim under the sun with respect to the issues that were brought up in the complaint and the notice of intent to file a claim in this lawsuit. You understand that, right?
Yes, I do.
Okay. And I understand that the liens were identified as $0 at this time, but to the extent any lien did ever arise out of the claims that are at issue in this lawsuit, it would be your responsibility to satisfy. Do you understand that?
Yes, I do.
Okay. Thank you. Those are all the questions I have.
Thank you. Mr. Marchena, any follow-up to any of the questions from Mr. Fadley?
No, Your Honor.
Okay. Again, the court had a chance to review the file prior to the hearing today. I did review the initial complaint, the affidavits of merit, and so forth, so that I understood the exact nature of the allegations regarding the conduct and the injury sustained. having reviewed all of that, having reviewed the settlement as presented and heard the testimony of Ms. Stewart here today, the court finds it would be appropriate and in the best interest of the minor to enter the settlement at this time. So the court will grant the motion. And I don't know, Mr. Marchini, was there any type of order or closing documents submitted with that?
No, Your Honor, but we can submit that right away for the court's review.
Okay, yep, so the court will enter that once that's presented. Mr. Marchini, anything else that the court can address for your side today?
Your Honor, I think just in terms of the order, we will likely submit just our order approving the settlement and distribution, and then counsel and I will then follow up with a stipulated order of dismissal and to close it out, if that's okay.
Yes, that sounds good. Thank you. Mr. Fadley, anything further from your side?
No, Your Honor, thank you.
Okay, thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you, Your Honor.
Okay, we've got council connected, so we'll go on the record in Cooper versus Beaver Creek Township. This is file number 2511863. If I could have both council put your appearances on, please.
Good afternoon, Your Honor. Warner Gruber on behalf of the plaintiff, Patricia Cooper, and the movement.
And good afternoon, Your Honor. James Lamb appearing on behalf of Beaver Creek Township, the board, and Kim Van Nook.
All right, thank you. We're on the record today as a result of some proceedings that occurred a few months ago. And as a result of that, the court had found, based on the statute regarding the Open Meetings Act, that the plaintiff was entitled to actual attorney fees. The plaintiff submitted a bill of costs. The court responded to that in that the actual attorney fees language of the statute required not just amounts that were billed, but the amounts that were actually paid by the plaintiff to her firm. That was then submitted by plaintiff, and then the plaintiff is now moving for entry of a money judgment for that amount. I did receive the motion in brief, Mr. Gruber, and then I also received Mr. Lamb, defendant's response. So in light of that response, Mr. Gruber, was there anything that you wanted to present to the court today by way of oral argument?
Not necessarily, Your Honor. Based on the statutory language, the court requested proof that the fees were paid, so that's what we provided. The court didn't request a fee petition on reasonableness. We, of course, believe that our fees are reasonable. I reviewed the Spiker case that Mr. Lamb relies on. In that case, the fees were reduced quite a bit because the plaintiff was seeking fees for a non-OMA claim in addition to the OMA claim. And I know they reduced the trial court, and it was sent back for an evidentiary hearing. I don't know what the results of that were, but the trial court reduced, or they said $250 an hour for 30 hours is reasonable. But based on inflation, we're really not that far off from what the trial court in that case said was okay.
Thank you, Mr. Lamb.
I think that's an accurate representation of the Spiker case. I mainly submitted my brief just to make the court aware that, just because it's actual attorney fees that's provided under the OMA, it's still in, the discretion of the trial court to consider the reasonableness of the fees that were charged. I guess to the extent an evidentiary hearing is necessary, I guess I would also leave that to the discretion of the court. But my initial thought on the bill of costs that was submitted is that at this point, there's really not enough proof to determine whether the hourly rate charged was reasonable at this time.
All right, thank you. So I did have a chance to read that case. I guess I had a little bit of a different interpretation of the holding in that case. I know counsel here have been kind of referring to reasonable attorney fees. And my reading of that case in the context of Open Meetings Act awards of actual attorney fees pursuant to statute, that the standard isn't reasonableness as it would be in many other cases where attorney fees are awarded, but rather that the court's review of attorney fees in the context of the OMA and actual attorney fees was that the fees could not be illegal or clearly excessive, not reasonable. So in my view, the court's analysis starts, number one, that the party claiming the attorney fees has the burden, whether it's actual, reasonable, or any other type of attorney fees, of showing the amount that should be awarded. The plaintiffs did comply with that. They complied with the court's request for showing of the amounts actually paid by Ms. Cooper, not just amounts billed, because those amounts can be vastly different. And so once that showing is made, then I think under Spiker, the burden then shifts to the defendants to show that those fees were illegal or unreasonable or excessive, I guess. I shouldn't use the word unreasonable, excessive or clearly excessive or illegal. Looking at the amounts in that case, and I kind of did look at what ended up happening in that case. And that was a 2012 case. The initial amount claimed was over $30,000. The court reduced that to $7,500, and the eventual award was somewhere in that neighborhood. In this case, the amount claimed as actual attorney fees is about $10,000. So, I tend to agree with Mr. Gruber, considering that was 13 years ago. I don't find that there's been any showing that those fees are clearly excessive or illegal in some way. And again, I think under the OMA award of actual attorney fees, in that case, that's what the court's looking at. It does seem like a lot at first blush when I saw it. And it seems, it seems to me unfortunate given what's gone on there in Beaver Creek Township. And I'll just leave it at that. I think there's plenty of blame to go around there. And while the OMA may not have been strictly complied with, I don't know that the award of this much of attorney fees is necessarily fair or just, but it is warranted under the statute. The court doesn't have any discretion. I think, the court doesn't have any discretion in whether or not to award attorney fees. The only discretion I would have would be that determination of whether it's excessive or illegal. Again, there hasn't been a showing that it's not. So I'm in a position where I don't think the court has any choice but to award that, whether I think it's fair or not. So the court will grant the motion in the amounts listed, Mr. Gruber. And I believe, did you submit an order with that?
There's an order attached as the last exhibit. There's a proposed judgment attached. I see that it doesn't have, well, obviously there's no signatures by the council as far as, approval as to form, but there is a judgment, proposed judgment as exhibit D. So if the court would like to enter that, or we can resubmit one after.
I don't mind entering. Yeah, I don't mind entering that. I always inquire of council when they attach it as an exhibit as to whether they want to submit a clean copy. But I'm more than happy to enter exhibit D.
That would be fine with us, Your Honor.
All right. Okay. Thank you. Mr. Gruber, anything further from your side today?
No, that's it.
Mr. Lamb?
Nothing further. Thank you, Your Honor.
All right. Okay. Thank you. That's all for this hearing today. Both counsel are free to disconnect at this time.
Thank you very much, Your Honor. Thanks, Jim.
Yep. Thanks.
Next we have a judgment from some retaining attorney we don't know about. Oh, that is Mr. That is Mertz.
Sir, can you unmute, please?
Yep. Sorry about that, sir.
That's okay. You're signed in under Jessica Lentine. Can you tell me your name, please?
Max Morgan Wells.
Okay.
That's my sister's.
Okay. If we have further hearings, if you can sign in and just put in your name, just so that I know, it helps me know who I have in the waiting room and what case they're on. I would appreciate that.
Absolutely.
All right, we have both parties present, so we'll go on the record in Wells versus Wells. This is file number 2512000. The record should reflect that both parties are present here today. And this was set as a status conference. I'm looking at the file. It looks like the parties went to mediation in December and that an agreement was reached. And so all we have left to do is enter a judgment of divorce. And so I'm going to refer to each of you by first name since you have the same last name. Max, is that how you wanted to proceed with entering a judgment at this time?
Yes.
All right. And Brian, is that how you wanted to proceed as well?
Yes.
Okay. All right. So what I'm going to need either or both of you to do, there's one final form. It's called the judgment of divorce. It's the final form that the court has to sign to finalize the divorce. What I can do today is take the testimony that I need to take from each of you, and then you'll have to submit that final form. It's important for you both to understand that until you submit that judgment of divorce and I sign it, this will not be finalized. So even though we're taking the testimony today, your case isn't done. And that's an extremely important final step for you to follow through on. Max, do you have any questions about that part of it?
Nope, completely understand.
Okay, Brian, do you?
Completely understand.
Okay, so I'm going to place you both under oath. I'm going to ask each of you a series of questions. The questions that I'm going to be asking each of you are those that I'm required to ask to establish the grounds for divorce under Michigan law. If you would both please raise your right hands. You both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Yes.
Thank you. You both can lower your hands. Max, most of my questions are going to be for you as the party filing for divorce in this case. You filed the complaint for divorce and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Crawford County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of the marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
Yes. Today. Yes. For today. Yes. Yes. It still does.
All right. Are there any children under the age of 18 that were adopted by you during the marriage?
No.
As part of the divorce, you are not going to be receiving any kind of alimony or spousal support. Is that correct?
Correct.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Absolutely. Understand.
And in terms of all the other assets or debts of the marriage, you've agreed about how to divide those things up pursuant to that mediation agreement that was put in writing on December 2nd. Is that correct?
That's right.
Okay, thank you. Brian, have you heard all the questions that I asked of Max?
Absolutely have.
Did you hear all of his answers?
Yes.
Do you have any reason to believe that any of the answers that he gave were untrue?
No.
Under the judgment of divorce, you also would not be receiving any alimony or spousal support. You understand that you also would be waiving that forever and would not be able to come back later and ask the court for that.
Yes.
And do you agree to abide by those terms of that mediation agreement of December 2nd, again, setting forth how any disputed assets or debts will be divided.
Yes.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. Again, I'm granting the divorce, but it will not be final until that judgment of divorce is filed with the clerk here in Grayling, and I've signed it. So, Max, is that something, usually it's the filing party that takes care of that. Is that something that you can provide to the clerk's office within the next 30 days?
Absolutely, yes.
Okay, so I'm going to require as an order of the court that you turn that in to the clerk within the next 30 days. I'm sorry, Max, do you have any further questions for me today?
Nothing today, sir, no.
Brian, do you?
No further questions, Your Honor.
Okay, thank you. That's all for this hearing today, and you're both free to disconnect at this time.
Thank you. Have a great day.
Thank you.
for those problems.
Are you representing him or are you filling in for Jason? Is that Jason?
I'm filling in for Jason.
Okay. And this is in case you did not have the product for it.
Okay, on the iPhone, can you tell me your name, please?
Yes, Your Honor, Robert Gray.
Mr. Gray, okay. All right, Ms. Gray, are you there as well?
I am, sir. I'm here.
Okay, so we'll go on the record in Marker Gray versus Gray. This is file number 2311522. The record should reflect both parties are connected by Zoom today. This is set for hearing. We had a hearing before with Ms. Gray. Mr. Gray, I did get your motion for today. I had a chance to review that. And so I know part of what you wanted was and you did that in writing, but can you kind of tell me where things are at from your standpoint, Mr. Gray?
Sure, Your Honor. I'd like to apologize first for not being to the last meeting. I guess I was confused on not getting a document from the court. I did call your court on October 24th and asked them if there was a court date. At the time, she said there wasn't one, but I didn't know, but I apologize. I'd just like to say that a lot of the stuff that she talked about was true. I did have a hard time paying the bills up until the end of June, or when we sold the side-by-side. I moved back downstate, I think in end of May, to live with my sister because I couldn't afford it up there. Got another job. I did find somebody to buy the side-by-side. They paid it. She had the money like I was supposed to get from the $7,000 from the first hearing. She paid off what I owed, and we had a verbal agreement that she was going to pay me the balance, but she didn't, and I understood why. And up to this point, she paid all my part of the bills. I don't owe her no money, and I think there's roughly like $480 some left, which we were going to use for propane. I just want to let the court know that I will pay my bills starting. I think I got to start making a house payment in February, and the rest of the bills. And I did not ever sabotage from selling the house. There has never been an offer on the house. There still has not been an offer on the house. I did let the propane did get down to 5%. It was probably 8% when I left, but one time she got up there, it was 5%. I didn't have the money, Your Honor. I did let her know that I was struggling. I called the electric company, like she said, and I wanted them to transfer it in her name. So I called her and let her know. And they said it takes about 2 weeks to do it. I didn't just leave the house with no electricity. You can't do that anyways anymore. So everything as far as I'm concerned is good with that. And that I just like to say that I've been in touch with the real estate agent and I'm willing to accept any reasonable offer like Sherry is. We never really talked about what price we both want, like a minimum. I'm sure we will do that in the near future. And that's really about it, Your Honor. I just want to end this. I guess what I'm saying is I wanted to talk to you because she was saying you were going to make a ruling possibly. I just didn't want you to make a ruling without hearing from me that I'm not trying to sabotage the house. There was never an offer. I do want to sell the house. I do know we're going to need to fix a few things up before we sell it. And I'll pay my half of the bills. Now that the money is going to be gone, I'll have to pay my half. And that's really about it, Your Honor.
All right. Okay. Thank you. Ms. Marker, is there anything you wanted to say today?
That I want to notify the court of. He's right in everything that he's saying. Never notified apparently that the lien was lifted on the house. I tried to contact the DA, but he wouldn't authorize me permission to speak with them. I needed his authority to speak with them. They won't speak with me. So I don't know. I've never received anything, no documentation as far as the lien being lifted. And that's why he's so, before he didn't want to sell the house. Now he's eager to sell the house because the lien's been lifted, apparently. And he says he contacted you, the court, and that he contacted me. I've never been notified of that.
I'm sorry.
Yeah, that's my only issue.
All right. So Is it fair to say that the issue with regarding Miss Marker, the issue that you had the last time we were here when Mr. Gray wasn't here, regarding getting the house sold, is that still an issue from your standpoint?
Well, he's telling me, I mean, he was texting, I have all the information, texting the realtor saying, don't waste your time. I'm not signing nothing. And then our
Well,
children.
I don't want to, we talked about that last time. I want to talk about where things are at as of today, because he's saying here on the record today that he's willing to move forward with it, and to get that done. So is that, as we sit here today, do you think that's still a problem?
I hope not. I'm
Okay.
taking for
Your
it.
Honor, Your Honor,
Yes.
December 4th, I received a text message and I have it here. I've made a copy of it from Sherry Marker saying, P.S. I heard through the grapevine that your lien was dropped with the feds. Any truth to that? And at that time, had no knowledge of it. So the next day I called downtown. Miss Brock is no longer in charge of this. I talked to the guy. He says, yes, we did a inquiry. There's no outstanding money gonna be coming in. So we closed it up. He goes, I'll send you the documents. You have to take one to Crawford County and you have to take one to City of Detroit, Wayne County, and file the deed, which I did Crawford County right away. I had an appointment yesterday with the Wayne County. I did it yesterday. It's all filed. There is no lien on the house. And when she texted me this, I had no idea, Your Honor, that the lien was off the house. All I knew was that January 14th, like we were in our divorce hearings, that it was coming off. But I didn't know. I would have told her. I didn't know. I honestly didn't know. Honestly didn't know. So
All right.
other than that, and one more thing, what she's talking about, the thing with the when I said I told the real estate agent, that was taken out of context, Your Honor, because me and her had a verbal agreement that once she sold the side by side, she would pay off my debt and she would send me my balance. At the time, it was like $4,200, and she said, "I'm not paying you." She kept on going on and on with her stuff about the divorce, how it went wrong, and then she also said, "I don't think you would pay me the bill." So nothing I could argue about. I didn't call a court hearing or ask for a court hearing. I just said, "Okay, fine. I don't have to worry about paying it." And that's why I said it. I just said I was mad. I was mad. I did say it to the real estate agent because she broke a deal with me. But obviously, it didn't happen and it's over with now. So it's been a bad divorce, Your Honor, as you well know. It's been terrible.
All right. So let's all assume for right now, because this is what you both are telling me here on the record, that everybody's willing to go forward, cooperate with the sale of the house.
Yes.
So let's assume that that's going to happen.
Yes.
Ms. Marker, are there any other issues left over from the hearing that we had that Mr. Gray wasn't at that need to be addressed?
I don't think so, sir. I just want to move forward, sell this house and.
All right.
Yeah.
Okay. All right. Very good. So I'm simply going to put in an order arising out of this hearing today that both parties are to cooperate with each other and with the real estate agent to accomplish the sale of the house. And let's move forward from there. Okay. All right. Thank you. That's all I have for today, and all parties are free to disconnect at this time.
Thank you,
Thank
sir.
you, sir.
Ms. Coker, are you ready to proceed?
Jason is next, Mr. Thompson is next door, on a different case. You're filling it, Jason was just texting me that
Okay.
the judge is giving us
Are you
ruling.
sure you're ready to proceed?
Yes.
It's on record in appeal versus
I have. The protected party is Kathy.
Mr. Miller, can you tell me what case you're signing in under, please?
Yes, Your Honor. I'm on Sherry Powers versus Keith Miller and Burke and Foster Burke.
Okay, very good. I'm just going to put you back in the waiting room for just a minute, and then I'll call your case shortly.
Thank you.
Yes.
Was sentenced to 16 years in 2022 for fatally stabbing a homeless man in 2017. A tragic end to the career.
Okay, let's see. We've got Mr. Carbajal connecting here.
I am here, Your Honor.
Okay, great. So we'll go on the record in Powers versus the State of Foster Burke. This is file number 2511999. If I could have both counsel put your appearances on, starting with plaintiff.
Leonard Miller on behalf of the plaintiff Sherry Powers, Your Honor.
David Carbajal, Your Honor, here on behalf of defendant estate of Foster Berkey only.
All right, thank you. This is, we're on the record here today for a motion to compel. Mr. Miller, your side has filed a motion to compel some statements that were recorded as part of, I believe, a police investigation into this incident involving the dogs. Mr. Miller, is there anything you wanted to state in support of your motion?
Yes, Your Honor. This matter arises out of an incident happening on Lovell Road in Grayling, Michigan. There were multiple dogs present. They ran from a home owned by Mr. Berkey. At his home at that time were his daughter and her partner, Mr. Miller. Complaint was filed against all three defendants because the police could not identify the owners of the dogs. Discovery has shown that Mr. Burke had a dog that matches the description. Ms. Burke had dogs. Mr. Miller had dogs. No one at the scene identified the owner of the dog, but everyone agrees the dog ran from the Berkey property. Ran in front of Ms. Powers, who hit the dog, went over the handlebars, and sustained serious injuries. A year later, a complaint was filed in this matter, and during the course of discovery, it was disclosed that there were recorded statements taken. We don't know from who. We anticipate they're from Mr. Berkey because he was the insured for the property. Ms. Berkey nor Mr. Miller answered the complaints, and defaults have been entered against them. Defendants refused to produce the statements that were recorded. Therefore, this motion was filed. Mr. Berkey is dead. It is impossible for us to get an equivalent statement if statements were taken from the insured regarding this incident. The investigation by the police officer, actually trooper, into this matter was limited to Mr. Miller, who was the then boyfriend or partner of Miss Berkey. And he was extremely evasive. Miss Berkey never came and spoke to the office. It's quite clear that Ms. Berkey nor Mr. Miller have responded to this court under the complaint, are in default. And if subpoenaed, their statements are subject to cross-examination, or their testimony would be subject to cross-examination. And because the amount of time that's passed and the statements given to the trooper, their credibility is at issue. Plaintiffs filed this motion in response. Defendants cited a case wherein work product privilege was claimed on the 11th day of a trial. And the court said, well, too late and no necessity because you've done extensive cross-examination here at trial. You, the defendants, don't need the statements that were recorded. Courts have also stated, as plaintiff has shown in his brief, there is no privilege for insurance adjuster privilege. There is no attorney-client privilege at issue here regarding these statements. The cases cited being Jones versus GM for the defendant and Michigan Rehabilitation versus Allstate for plaintiff. Make it clear, plaintiff's entitled to these recorded statements because of impossibility of obtaining that of Mr. Berkey and the amount of time and undue burden placed upon the plaintiffs in preparing for a cross-examination without these statements, if they are of Ms. Berkey, or Mr. Miller.
All right, so Mr. Miller, what you're asking Mr. Carvajal to turn over our statements that those individuals made to the insurance adjuster or as part of the insurance company's investigation, is that what you're saying?
I'm assuming that they would be by Mr. Berkey, who's the insured. We don't know. Yes, we would like all of the recorded statements turned over.
Okay, all right, thank you. Mr. Carvajal?
That's correct, Your Honor. I'm going to represent to the court that there was a statement taken of Jeanette Martin, who was accompanying the plaintiff. The ladies were bicycling on the roadway. Her statement was taken by an employee of Farm Bureau on 6/18/2024. And this is by telephone. The recorded statement, I believe, was taken by or from Ann Berkey, also the same date, 6/18/2024. There was an independent witness, Jason Boft, the BOFT. I think his recorded statement was taken 6/20/24. And then my client's decedent, the late Foster Berkey, he was, I think a statement was taken from him on 7/2/26. And to be clear, Judge, this isn't a dog bite case. This is a case where a dog runs out on the road and the plaintiff may be in the front of the wheel and the plaintiff trips over it and claims injury. The dog has not been identified. The plaintiff says it's a white dog. My client's dog is and was actually my decedent's dog was not white. So there's a question as to whose dog it was and that sort of thing. So that kind of presents a case. So, Judge, the accident in this case happened on June 11th, 2024. 7 days later, the plaintiff, Mrs. Powers, made a claim again and informed the Farm Bureau that this accident had occurred and she had been injured. Thereafter, based on Mrs. Powers' claim, Farm Bureau commenced its investigation on behalf of its insured. In this case, the plaintiff has not taken one deposition. The plaintiff has not deposed any of the police officers, has not deposed or attempted to depose Jason Boft, Ann Berkey, Jeanette Martin, and has done nothing to prove to this court that, first of all, that the statements that were taken pursuant to a claim that was made by the plaintiff, where she's making a claim to essentially against my client, the decedent, and the insurance company immediately starts investigating the claim, gathering information, taking statements. That's privileged work product. And more importantly, Judge, they haven't established to this court any substantial hardship or undue burden. I mean, about the only thing that remotely would qualify is we can't talk to Mr. Berkey because he's dead. Well, the triable issue in this case, as I identified to the court, was what dog did this, or what dog was involved, and where did that dog that was involved come from? It certainly did not, it's not my client's decedent's dog. So we need all the wealth of those facts, Judge, to be determined, so that then maybe later, after we take several depositions, they can say, Judge, we tried, we just can't figure out what dog it is. And we need and want and have to have the decedent's testimony. Then when they make that showing to this court can then have that information before it to make that determination, say, you know what, plaintiff's counsel, you're right. I agree that you can't talk to Mr. Berkey. But I don't think that you need, I need to invade the work product privilege, or I do need to invade the work product privilege, but not today, Judge. I mean, they haven't done anything.
Well, defense counsel has no idea what plaintiff has done. We have records from the Grayling Animal Hospital showing that defendants, Ms. Berkey and Mr. Miller, had several dogs. We have evidence that Mr. Berkey, the decedent, had dogs and complaints against the dogs running loose. With regard to the claim of work product privilege, Michigan does not recognize or acknowledge a general insurance or claims representative privilege, nor does Michigan recognize a general insurance investigator privilege. These are statements of fact that plaintiff needs in order to pursue its case against all three defendants. We will depose the remaining defendants once we're able to determine the documents and statements they've made, and during deposition use those statements if they are applicable to the credibility of the witness. Discovery for that purpose is certainly allowance, not privilege.
Your Honor, that's funny.
Go ahead, Mr. Carwell. I'll give you one last statement.
Yeah, Your Honor, that's funny, because I think there's a court rule. I was trying to find it as plaintiff was talking. There's a Michigan court rule that says that the work product privilege extends to insurers and representatives, not just the plaintiff. The whole idea is whether they were taken in anticipation of litigation, Judge. That's kind of the threshold inquiry. I've indicated to the court, from the information that I have, Judge, and it's a note that I reviewed just before that the accident, that it's a week later that the plaintiff contacts. And it's just, we need to take these depositions, and I don't know why they get to have my work product and I don't get to have theirs. It's just not fair, and the rules that require that they comply and establish those threshold issues, one. And then if the court finds that it's indeed a privilege, whether they can't get the equivalent otherwise. They have not established that, Judge. Now, one depth.
All right. Okay. Thank you. I did have a chance to review the briefs of the parties prior to the hearing today. I've had an opportunity to hear an argument of counsel. As both counsel are aware, under the rules of civil discovery, both sides and discovery under Michigan law, both sides are entitled to free and open discovery of materials that are relevant and non-privileged. Work product is a privilege that's applicable in this case. I do agree with Mr. Carvajal that work product privilege can extend beyond that of simply the attorneys that are working on the case. And in this case, to insurance representatives, as indicated by counsel, one of the key requirements is that those materials be prepared in anticipation of litigation. Even if there is some privilege or work product protection, plaintiffs are still not prevented from obtaining discovery, particularly of factual information and factual statements such as those at issue here. Again, plaintiffs aren't seeking notes, thoughts, theories, strategies and so forth that may have been recorded by the adjusters or anyone else. Plaintiffs are simply seeking factual statements made by the individuals who were interviewed. So upon a showing of cause, and as indicated, cause indicated by the plaintiffs in their brief, cause is can be based on necessity. And in this case, given the status of discovery at this point, I agree with Mr. Carbajal that there hasn't been an adequate showing of necessity at this point. I think certainly Mr. Miller raises some excellent issues that may arise through the course of discovery and their attempts to get statements from some of these individuals, such as the defaults, obviously with Mr. Berkey being deceased and so forth. There may come a point during the course of discovery where plaintiff has exhausted their available options to get this information, and the only other avenue left is production of these additional statements made to the insurance company. And so at that point, I think plaintiff may be justified in that discovery. So what I'm finding for purposes of the motion today is that the motion to compel is premature. The court is denying it without prejudice at this time, but at such time as the plaintiffs would be able to come back with a more adequate showing to the court that they don't have any other reasonable means of obtaining this information, and the court would certainly entertain that motion again.
With due respect, Your
Mr.
Honor.
Miller, as the moving party, I would request that you prepare an order that reflects the ruling of the court here today and submit that under the 7-day rule. And you had a question, Mr. Miller?
I did, Your Honor. With regard to Mr. Berkey, the decedent, at a minimum, I believe, with due respect, if he has a recorded statement, we can't obtain it by any other means. With regard to the other 3 statements, I understand the court's position, and I respectfully prepare the order as the court directs, but would request that Mr. Berkey's recorded statement be produced. We have no other means of obtaining it.
Well, you may have no other means of obtaining that exact statement, but it doesn't mean that you don't have other means of obtaining the information that was provided. And so, again, to the extent that the plaintiffs run into a dead end on that, and that's the only other way, pursuant to my ruling, again, you're more than able to bring that motion again at a later time.
I will submit a simple form order to the court of denied without prejudice.
Very good. Thank you. I appreciate that. Thank you both, counsel. You're both free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
So can we let defense counsel know or somebody?
Thanks.